Now, my name is Roger Alford. I'm a law professor at Notre Dame Law School, and I have the distinct privilege of having an incredibly minor role, which is introducing the moderators. So I'm the moderator of the moderators. And I just wanted to start by saying thank you for Manjuka for generating this wonderful panel and this great idea. I wanted to thank you and then Cesar also, who is a macroeconomist in the business school at Notre Dame, for moderating this event. And then let me also give credit to our student leaders. This is co-sponsored by the Business Law Society and the International Law Society, the Business Law Forum and the International Law Society. And they did a lot of stuff promoting the event around the law school. So it's a great topic, super important. And we just thank both Manjuka, you and Cesar for organizing it and moderating it. So maybe I'll leave it, Manjuka, to you next.
Thank you, Professor Alfred. I mean, Professor Alfred has been a mentor for the last, I don't know how many years. Just would you bear with me? I think Justice Desilva is trying to get through. Let me try and sort this out for a minute.
Maybe start with Cesar then, if you're going to troubleshoot that. Cesar, go ahead.
Sure. Thanks a lot for the introduction, and thanks to all the panelists for agreeing to take part in this. So I suppose, since Justice Desilva is the first in the order of business, maybe we can wait a second. But essentially, what we'll do is Justice Desilva will go first, then Reza will go after him, and then so Manjuka will coordinate the first two presenters or speakers, and then I'll take over and we'll continue with Bruno, and we'll close with Patrick, and then after that we'll open the floor for Q&A, and hopefully we'll have questions from the audience. Also, as we go, I'll keep track of the questions. So if you have questions, you can write them in the chat, and both Manjuka and I will make sure to present the questions to the speakers.
I do apologize. I'll take over. Thanks, Cesar, for standing in. I'm sorry, that was a bit of a housekeeping thing. We had to keep Justice Desilva was finding difficult to connect, so I had to attend to that. So today's panel, we have 4 distinguished speakers today. First is Justice Janak Desilva, who is a Justice of the Supreme Court of Sri Lanka, who prior to being appointed judiciary was a member of the Attorney General's Department. His last position in the Attorney General's Department was a senior Deputy Solicitor General. Justice Desilva, whilst in the Attorney General, was responsible for advising the government of Sri Lanka on bilateral and multilateral loan contracts, particularly the Chinese Exim loans, which are these days very much on the spotlight. He was responsible for drafting the issuer's opinions in sovereign bond transactions. Justice Desilva's true passion is investment treaty law. He has represented Sri Lanka in several exit arbitrations and was a member of the committee which drafted the updated model bilateral investment treaty for Sri Lanka. Justice Desilva holds a Bachelor of Civil Law from the University of Oxford, LLM from University College London, is a Shell Century Scholar and Hubert Humphrey Fellow. He spent his fellowship at the Hubert Humphrey Fellowship at Michigan State University and worked at the trade practices of the Washington office of the law firm Dewey and Ballantyne LLP. He's also honorary bencher of the Gray's Inn of London. Our second speaker is Reza Baqir. Reza is the former governor of the Central Bank. Prior to that, he was the head of the debt policy division of the IMF. He spent almost 19 years of his life in the IMF. He's currently the managing director with Alves and Marshall and global practice, the leader of the Alves and Marshall's sovereign advisory based in Dubai. Reza earned a Bachelor of Economics degree from the University of Harvard, magna cum laude, and a PhD in economics from the University of California, Berkeley. He's currently a senior fellow at Harvard Kennedy School, working in areas related to sovereign debt. Bruno Ciuffetelli, Bruno is a legend in sovereign debt restructuring as a lawyer. He's head of the practice of the global law firm Hogan Lovells. Bruno advised the government of Ecuador in his much celebrated 2021 sovereign debt restructuring, which was concluded smoothly in record 6 months' time. He's currently advising the government of Ghana in its domestic as well as external debt restructuring, and much looked at to everybody looking at that to follow. And Patrick Curran is the other speaker. Patrick is a senior economist at the Tellimar Research. Prior to joining Tellimar, he worked at Eaton Vance in Boston, conducting sovereign fixed income analysis. And he also spent time at the South African Reserve Bank in Pretoria. He holds a Master of Arts in International Economics at Johns Hopkins Advanced School in Washington, and a CFA charter holder. To start proceedings, Justice Desilva, are you there, or shall I will start with that? Yeah, I can see him. Thank you. Justice Desilva is the first speaker, and Justice Desilva will speak about the legislative framework regulating issuance of international sovereign bonds and bilateral contracts in Sri Lanka. What drives choice of law clauses in sovereign debt contracts and contents of bilateral agreements. He will compare between the Chinese agreements and Paris Club member agreements, and challenges the transparency reporting debt based on Sri Lanka's experience. And he will finally talk about, is there a need for the IMF to encourage the development of standard form contracts or bilateral debt contracts akin to ICMA forms. Over to you, Justice Desilva. Yeah.
Thank you, Manjuka, and thank you for the. Can you hear me, Manjuka?
I can hear you. I think there are some slides we need to be shared. Is that possible to be shared?
Yeah, Chris is going to share those.
Okay. Right, that's brilliant.
Thank you, Manjuka, and thank you for the organizers for having invited me to take part in this webinar. My presentation is in two parts. Firstly, I will speak about the legal framework relating to foreign loan agreements in Sri Lanka, and in particular, parliamentary control of agreements. And secondly, I'll refer to certain selected clauses in bilateral and multilateral loan agreements in the context that Manjuka referred to. Since independence, if I may refer to the first slide, Sri Lanka has been having a Westminster model of government, of which an essential characteristic is that Parliament has full control over public finance. So all the constitutions since independence has specifically provided for such parliamentary control. And if I can go to the second slide, the parliamentary control itself has three specific components. Firstly, Parliament controls the sources of finance, and in this sense, sources includes both local and foreign. And generally, public finance is generated through taxes and borrowings. Borrowings can be both local and foreign. And in the context of parliamentary control over public finance through borrowing, the control is exercised both in relation to local borrowing as well as foreign borrowing. The second component of the parliamentary control is by Parliament itself allocating the public finance to different organs of government. That is by the annual budget. The third component is that having so allocated the finances, Parliament continues to have control through audit and examination of due diligence in the performance of the functions of government. Insofar as the audit function is concerned, it is through the Auditor General that the exercise of control is done, and the Auditor General is constitutionally under a duty to audit all accounts of government, ministries, departments, and public corporations. The second way in which the control is done is through two finance committees of Parliament, namely the Parliament Committee on Public Enterprises and the Committee on Public Accounts. If I can go to the third slide. Thus, in theory, when government is borrowing either through the local market or the foreign market, there had to be parliamentary approval because of the creation of a debt. But as far back as 1957, the Foreign Loans Act was enacted, by which approval in advance was given for the entering into of foreign loans. And that was through the mechanism of, at that time, the Governor General and now the President, authorizing a public officer to enter into the foreign loans. And in that sense, Parliament does not have advance notice of the entering into of a particular loan agreement, because it has already authorized the President to authorize the public officer to enter into such agreements. The types of instruments that can be entered into in terms of the original act was an agreement relating to a foreign loan or any contract, bond, promissory note, or other document that was required to be executed by such agreement. The original act defined a foreign loan to be a loan in any currency which was granted by either a foreign government, the agency of a foreign government, or an international organization, or body of persons outside Sri Lanka, as by the government of Sri Lanka. And it also provided for the government to enter into any agreement with any person who undertook to discharge the liability of the government under a loan agreement. If I can, the next slide. Generally, all funds coming into the government and all funds that had to be paid by the
So Justice Desilva, excuse me, I think you muted yourself.
Okay. Can you hear me now?
Yes, we can hear
Yes,
you now.
now it's okay. Yeah.
Sorry. Generally, any sum that has to be paid by the government has to be paid through the consolidated fund, which required specific approval of Parliament. But due to the Foreign Loans Act, any sum that had to be payable under a foreign loan was automatically charged on the consolidated fund, so that specific parliamentary approval was not required for payments to be made on a foreign loan. Towards the end of 1970s, the government of the day changed its economic policy for an open economic policy. And in that context, the public corporations and public enterprises were called upon to play a greater role in the economic activity of the government. And in doing so, obviously there was a need for finances. And in order to generate such finances, the Foreign Loans Act was amended in 1980, which essentially and primarily provided or enabled the government of Sri Lanka to provide guarantees to foreign loans to public corporations and public enterprises. Public corporations was generally meant to be any corporation, body, or other body which was or is established by or under any written law other than the Companies Ordinance, with funds or capital wholly or partly provided by the government of Sri Lanka by way of grant, loan, or otherwise. And public enterprises is defined to mean any company which is registered under the company's ordinance in which the government of Sri Lanka holds not less than 50% of the paid capital. So through this device or the amendment in 1980, both these entities were enabled, one, to obtain foreign loans, and secondly, the government to provide a guarantee for such loans. Next slide, please. Thank you. Initially, the Foreign Loans Act provided only for foreign loans in the form of currency, and it was a very narrow definition. But due to the evolving capital markets, in 1984, the Foreign Loans Act was amended to expand the definition of foreign loan to include any loan or any form of financial credit or accommodation in any currency other than Sri Lankan rupees granted to the government, to a public corporation or public enterprise. And hence, it is through this mechanism that sovereign bonds can be issued by the government because of the extended definition that was enacted to the Foreign Loans Act in 1984. Now, in 2003, the government enacted a very important legislation, namely the Fiscal Management Responsibility Act. And it provided initially, or it sought to ensure that there is transparency in the fiscal policy and fiscal management of the government. In terms of this act, 4 basic statements had to be presented to Parliament at different types of the year. The fiscal strategy statement required, amongst other things, to specify for the succeeding 4 financial years the government fiscal objectives in relation to government debt. The Budget, Economic and Fiscal Position Report required the Parliament to be kept informed of estimates relating to government borrowing and the risks that have a material effect on contingent liabilities, including guarantees and indemnities granted by the government. This is a reference to the amendment to the Foreign Loans Act, which provided the government to provide indemnities to public corporations and public enterprises loans. The third report, the Mid-Year Fiscal Position Report, required the Parliament to be kept informed of the estimated and actual borrowings for the first 4 months of the year, while the final Budget Position Report required a statement of the estimated and actual borrowings for the whole year. Thus, in addition to the annual budget being presented to Parliament and the Parliament approving it every year, this act sought to ensure that the Parliament was kept informed throughout the year on the fiscal strategy and the management of the policy of the government. If I can have the next slide, please. As a whole, the Fiscal Management Responsibility Act sought to ensure that the financial strategy is based on principles of responsible fiscal management. And in order to achieve this, certain objectives had to be achieved by the government during each year. If I can have the next slide, please. So, in order to ensure principles of responsible fiscal management, amongst other things, the government was directed to reduce government debt to prudent levels. It was required to adopt policies relating to spending which do not increase government debt to excessive levels. It also required the government to ensure that at the end of the financial year 2006, the total liabilities of the government do not exceed 85% of the estimated GDP for that financial year. And fourthly, it required the government that at the end of the financial year 2013, the total liabilities of the government should not exceed 60% of the estimated GDP for that financial year. Now, these were goals set in 2003. And the two years that were relevant in terms of the 2003 Act was 2006 and 2013. But however, an amendment was brought in 2013, which, can we go to the next slide, please? Thank you. An amendment was brought in 2013, which gave an indication at that time the economic condition of the government, because by the 2013 amendment, what was to be achieved by the end of 2006, that is 85% to bring the total liabilities to 85%, it was extended from 2006 to 2013. And the other goal of achieving 60% of the GDP of total liabilities was extended from 2013 to 2020. A further amendment was brought to the last goal in 2021, so that the 60% of the estimated GDP goal for the total liabilities was extended until 2030. So this basically gave an idea about the economic condition that the government was facing as far back as 2013 as well as 2021. If we can go to the next slide, please. Although the financial reporting to Parliament was strengthened through the Fiscal Management Responsibility Act of 2003, there was an instance where the Supreme Court had to make certain observations on a lack of proper reporting in the exercise of its constitutional jurisdiction, because in Sri Lanka, what we have is a pre-enactment constitutional review, so that the appropriation bill could be challenged before it is passed in Parliament and not after. And insofar as the appropriation bill for 2009 was concerned, when it was challenged, on one ground on which it was challenged was that the external liabilities were not properly reflected in the appropriation bill that was placed before Parliament. And this is what the Supreme Court said at the end of the day. The government is caught in a veritable debt trap, in which debt service payments for the current year are made by raising further debt in that year, thereby increasing the debt service payments for the succeeding year. These facts have been kept away from the public domain by the statutory device of excluding expenditure under any other law. The staggering debt service payments of rupees 722 billion for the financial year 2009 reflect an accumulation of public debt over the past years that has resulted from irresponsible and reckless handling of public finance by the Treasury, and a failure on the part of Parliament to exercise full control of public finance as mandated by Article 148 of the Constitution. So that basically covers the first part of my presentation, on which I wanted to touch on the parliamentary control of public finance, the legal framework governing the raising of foreign loans by the government. I will now briefly touch on certain clauses in foreign loan agreements which raise concern, mainly from a developing country perspective. If I can go to the next slide, please.
That's all the slides that we have.
Yeah, I'm sorry. The rest of the in relation to the clauses in foreign loan agreements, some of the clauses which are of concern to developing countries, in particular in the present situation, is the cross-default clauses, where the foreign lender ensures that whenever the government is in default of any other loan agreement, there is an automatic default in the loan agreement, which is the subject matter or which is of concern to the lender. And what you find in these clauses, the cross default clauses, is that it is worded in a way where not only the government default is covered, but any default of any public enterprise, public corporation, or any government entity is covered, obviously to protect the interest of the borrower. So that is a matter that is of concern to developing countries because of the existence of different governmental entities which are also market borrowers. Then you find invariably a waiver of sovereign immunity clauses where the government makes a statement that the loan agreement is a commercial act, and therefore the sovereign immunity that a state generally has does not apply to the loan agreement and the activities covered thereafter. You also have the pari passu clauses, which the lenders seek to ensure that insofar as the lenders to the government is concerned, all of them are going to be treated in the same way. This is somewhat similar to the most favored nation treatment, which you find in investment treaties as well as free trade agreements. One clause which is generally negotiated in greater detail or sought to be negotiated from a developing country perspective is the choice of law clause. Now, the lenders will obviously want the loan agreement to be governed by a choice of law, which they have control over, they are comfortable with, and to take it outside the control of the borrower. Insofar as Sri Lanka is concerned, we have a system where our common law is the Roman Dutch law, while English law applies in certain areas, in particular in commercial areas. So to that extent, when the borrower insists on English law as being the governing law, it does not create that many problems. But when it is a choice of law which is totally unfamiliar to the borrower, then the legal counsel have certainly a concern in relation to accepting such clauses. There is also a clause which takes the jurisdiction away from the borrower's court and either places it in the lender's court's jurisdiction or any other court which is outside the borrower's jurisdiction. In countries where you have an English law application, that is somewhat reduced, but in countries where a choice of law is completely alien to the country and the courts of the jurisdiction that is sought to be enforced is completely alien, it is a matter of concern. However, there have been instances where it has been possible to agree even on the application of domestic jurisdiction to the agreements. An example is the free trade agreement between Sri Lanka and Singapore, where under the exhaustion of local remedies clause, investors are required to litigate in the host country's courts for 2 years, failing which you have recourse to international arbitration. So there have been instances where it has been possible to negotiate away from the choice of law or the jurisdiction of one country and make it applicable to both. So those are basically the clauses that I would like to refer to. And insofar as the restructuring of loan agreements are concerned, generally you don't see restructuring clauses being specifically included in loan agreements. What you find in most loan agreements are the normal clauses that you find in any contract, which says that it cannot be modified unilaterally, that it can only be done through the mutual agreement of the parties and that too in writing. So in the absence of any specific restructuring clauses, the general clauses that are seen in most agreements, which requires the agreement of both parties to be in writing, is probably the clause that will apply in a restructuring context. And that is all what I would like to refer to at the moment. And once again, I would like to thank the organizers for having invited me to make this presentation.
Thank you, Justice Janak Desilva. Thank you for your wonderful presentation and your insight to some of the documentation that people are trying to will be negotiating in the few months to come in the clause. Some of what you have written would be negotiated, would be looked at in minute detail. Now I have the pleasure of inviting Reza to give his presentation. So Reza will speak on comparability. He will speak on the common framework. So over to you, Reza. I had the singular honor of listening to you.
Thank you, Manjuka, for organizing this. And I want to thank Roger, everybody else who's been part of this. And I really want to congratulate Justice Desilva on a very, very lucid, clear presentation, which I found very useful as well. Manjuka, before I get into what you had asked me to speak about, am I at liberty to ask one question of Justice Desilva, which I am burning to ask?
Please do.
With your permission, Justice Desilva, I was struck at one stage in your presentation about a law that says that debt cannot be more than 60% of GDP. So I wanted to ask you, how come, if there is that law, debt in Sri Lanka has risen much beyond that?
Yes, I think you are referring to the provision in the Fiscal Responsibility Act. That was the target set in 2003. And the two targets were 80%, if I'm not mistaken, by the end of 2006, and 60% by end of 2013. As I pointed out, it was amended in 2013, so that 80% was brought back forward from 2006 to 2013, and what had to be achieved in 2013 of 60% was extended till 2020, and then amendment that was brought in 2021 extended that till 2030. So as to whether that target has been achieved or not during that period, I don't know, but all what I can say is that the time period initially put by the main act in 2003 was extended by 3 acts in 2013, 16, and 21.
Thank you. Just I'll move on, but just will make two observations. One, I asked about this because I was at the IMF for a number of years, and the reason these laws were introduced, and I wonder also if part of the background of the introduction of this law in Sri Lanka's context may have been in the context of an IMF program, but they were typically introduced because it was thought that having a law that stipulates a limit will act as a coercive or as a enforcer of fiscal discipline. And I think how you've explained that when it came to be a constraint, simply the law was changed, I think also raises questions about how effective such fiscal responsibility laws have been. It's a separate issue, but I think a very relevant issue, because at the end of the day, we are all talking about how to avoid unsustainable situations from coming up. And in many countries where this is a repeated issue, it was thought that legislating laws would provide the answer. The second point I wanted to mention, just for your interest, is that Pakistan has an exactly similar law. Pakistan has also had multiple IMF programs. But in Pakistan, if I understand correctly, the law was never changed. It's just repeatedly not complied with. And when the budget statement was presented, as I understand it, there is a statement by the Treasury saying that for such and such reasons, the debt will exceed what is listed in the law. So whether it's done through that mechanism or through this mechanism, I think both the experience of Sri Lanka and Pakistan as a separate paper or research note, and I don't know how many other countries have such experiences, I think is a good case study on fiscal responsibility laws. Let me quickly speak and address the areas that Manjuka asked me to address. And I want to, first of all, also say, Justice Desilva, and to you as well as to Manjuka, that I hope Sri Lanka is able to come out of its debt crisis that is facing right now and is able to restore normalcy and particularly market access. But especially important, I hope that crisis is also an opportunity for reform. And I hope that those reforms are done, which will address the underlying causes that led to debt unsustainability, particularly the structural causes, whether it's state-owned enterprises or whether it's other parts of the public sector, such as the tax effort and so forth. Now, Manjuka had asked me to speak on the issues related to debt restructuring, particularly comparability of treatment and related issues. I'll be speaking from my perspective, primarily as having headed the debt policy division of the IMF for 4 years, between 2011 and 2015. And I'll also be speaking a bit from my perspective as the former governor of a central bank of a country that has high public debt. Now, I should concede at the very beginning that this issue of comparability of treatment is one of the hardest issues that we confront right now. And in my remarks, I should say up front that I will not really be providing any answers, but I do hope to raise a number of relevant questions. And these are the questions that I have found to be most pertinent from my own experience as having been involved in debt restructurings from the IMF side first. And then as I used to think about these issues when we had the COVID crisis and the international financial community launched the BSSI initiative, of which Pakistan also participated in that as well. Now, I want to start in talking about the issue of comparability of treatment by actually taking a step back and looking at this issue from a broader perspective. Comparability of treatment typically means how are different classes of creditors treated. And there quickly becomes a very specific literature on this issue. For instance, people would be familiar by the note that was done by Lazard recently on how to calculate comparability of treatment. There is the Paris Club language itself. There is a World Bank note. There are many others as well. But it quickly becomes a very specific issue as to how do we see that the different classes of creditors are being treated in comparable terms. To me, the issue is relevant, not just as an issue in itself, in terms of intercreditor equity, but to me, it is primarily an issue of interest to the extent that it affects the probability or the timeliness of getting an efficient debt restructuring deal concluded. To me, that is the most relevant perspective from which we should even be discussing this issue, that is our number one goal. And I want to, therefore, put this in a more general context, that what is ultimately at play here is burden sharing. And I prefer to think in terms of burden sharing as the most important consideration that all the stakeholders need to be mindful of. And then as a subset of that, this comparability of treatment across creditors. Now, what do I mean by burden sharing? What I mean is that, the story of debt restructurings is that a country has essentially found itself between two different stages. There used to be a time when whichever country we're speaking about used to be enjoying healthy, good relations with its creditors, had an economy that was doing well, and this country was being able to borrow from creditors without any issues. And creditors, in turn, were very happy to lend, whether it was official creditors that were lending for particular official reasons, including foreign policy-related reasons or other strategic geopolitical reasons, or commercial creditors who were very confident that the country was a good credit risk at the yields that were being offered. There was that stage of the country. And then there is a stage of the country that it is currently in, where it is in economic crisis and unable to make its payments. Now, the journey from the first stage to the current stage is a journey, obviously, of some missteps. Some may be domestic, i.e. missteps of one's own doing, as far as the debtor is concerned, and some may be exogenous. But what I see is very important is that when all the stakeholders are working to get the country out from the current stage and back to the stage that it used to be in, that it is important that everybody perceives that there is some burden sharing in getting the country back from its current stage to where it was. I see three main actors that need to demonstrate burden sharing. First is the country itself. And the country needs to demonstrate that it is undertaking difficult economic reforms to address the underlying cause of debt unsustainability. This is to me critical because a reason that the country is in debt default or in debt distress is that certain difficult economic decisions were not undertaken. So the first key actor that needs to demonstrate burden sharing is the debtor itself. The second key player in burden sharing is the institution that is the lender of last resort that is putting up fresh money and is not going to be subject to a haircut when it puts up fresh money. This is typically the IMF, many times together with the World Bank or other multilateral organizations. And the third key stakeholder in burden sharing is what I would call all the other creditors, aside from the lender of last resort, all these other creditors that are gonna provide debt relief. Now, the reason I mention these three groups or these three key stakeholders in burden sharing is that, to me, successful restructurings are the ones where the debtor in particular undertakes a process that demonstrates that due and careful attention is being given to burden sharing between these three groups. And there is a balance. For instance, the greater, when I mentioned the first part about burden sharing, which is the burden that falls on the country itself, the greater the adjustment that a country does, and by adjustment, I mean the greater the taxes that a country raises, or greater the expenditure that it cuts, or the greater the painful economic reforms that it undertakes, or the pain that it puts on the citizens, the greater the adjustment by the country itself, the less is the ask of the country of the other two stakeholders. Because if you do more adjustment, you need either less financing from the lender of last resort, or you need less debt relief because you'll be generating those resources from the adjustment that you're doing. Second, again, talking about the need to strike the balance, the greater the amount that is lent by the lender of last resort, the less the need for adjustment on the part of the country, and the less for need for debt relief from all other creditors, bilateral, official, as well as private creditors. And finally, the third stakeholder, the more the debt relief from all the other creditors, the less the need for adjustment and the less the need for the amount of lending by the lender of last resort. Successful debt restructurings, to me, demonstrate that there has been a balance that has been struck between the burden sharing between these three key stakeholders. Is there a formula to that? No. I think what is very important is not only the content of how this burden sharing is achieved, but also the process, and including the perception of the process and all the actions that are undertaken by the debtor to act in a timely manner in good faith to demonstrate it's doing its part, it has done, the IMF has done its part, and that it is making the right representations early with the creditors to share as much information as it can. Now, this was the general point that I wanted to make, that it is useful, in my view, to put compatibility of treatment in this broader context of burden sharing, and to think about these three stakeholders and to ask oneself, are we striking a good balance? Now, let me now make my second point, which is more specific. and which is practically, how is this done? Now, ultimately, the institution that has the final say to a large extent in how this balance is struck between these three stakeholders of burden sharing is the IMF. The lender of last resort when the IMF team prepares its macro framework, by which I mean the assumptions of growth and inflation, a path of budget deficits that is consistent with sustainability, a balance of payments table, a debt sustainability analysis table, and other such tables. The IMF has, first of all, essentially made the determination of the balance between adjustment and financing, i.e., it has already, in consultation with the country authorities, made a call on how much would be politically and socially feasible for the country to do by way of either new taxes or expenditure cuts or other. And once that determination has been made on the balance between adjustment and financing, the next step is that the IMF decides how much it's going to lend itself. And there the IMF, first of all, has to decide whether it's normal access or it's exceptional access, which essentially is IMF's jargon for saying whether it's very large amount of lending or not a large amount of lending. And the IMF has different rules. There is an access limit. So if the IMF is not going into exceptional access, there is a ceiling on how much the IMF can lend. But if the IMF makes a determination that it can lend exceptional amounts, then there is no limit to how much the IMF can lend. It is its judgment, taking into account its own safeguards, i.e., its confidence that it will be repaid as a lender of last resort, that determines in part how much the IMF decides to lend. But the next step is that the IMF makes its own decision as to how much it is going to put on the table. So once the amount of adjustment has been determined, once the IMF or the lender of last resort has determined its own contribution by new money, one is left essentially with the envelope of resources that is available to service the claims of all other creditors. And that is when we typically have all these discussions in terms of the compatibility of treatment and intercreditor equity and a whole host of related issues. Now, in the Q&A or separately, happy to get more into a discussion of what are some of the specific proposals out there. But I want to make a point that is important to me, which is that as we get into these discussions of how is this, financing that is needed from the creditors going to be shared amongst them, to me, what is important is to not lose sight of the goal. And the goal is the quickest and the most efficient way to get the debt restructuring done, and especially to reestablish market access. I have found that it is often tempting in such circumstances to treat the private creditors as the residual, i.e., to try to inflict the greatest possible losses on them at the expense of other types of creditors. And my takeaway from my experience is that it is in the interest of both the official creditors and the debtor country itself to be seen as making efforts to achieve burden sharing and to not be seen as treating the private creditors as a residual. And the key reason I say so is that it is ultimately the reestablishment of market access that is going to allow the debtor to repay its official creditors, to repay the most preferred creditors as well. And so it is important that private creditors and the market feel that there has been some burden sharing as this split has been made. So let me stop over there. And I know we're running a bit late as well, and there are many other very, very important speakers as well. And, separately, I'm happy to come and talk more about some of the specifics, which I'm very happy to do so, whether when you compute compatibility of treatment, do you want to use exit yields? Do you want to use a specific discount rate as in 5% of the LIC DSF, you know, whether you want to use in terms of the denominator, the face value of debt, present value of debt. Happy to discuss all of these specifics. I wanted to put this in a broader context that what is very important is how these things are actually done in terms of sequencing, the fact that we should not lose sight of the broader concept of burden sharing. Country has to demonstrate it is doing its part. The IMF has to demonstrate it is putting sufficient resources. And the rest of the creditors need to demonstrate that they are providing sufficient debt relief. And that to me is the most important consideration and goal to keep mind of to conclude the debt restructuring. So let me stop there, Manjuka.
Yeah. Cesar, will you take over?
Yes, perfect. Okay, so thanks to Reza and Justice Desilva for their presentations. Now we're going to continue with Bruno Ciuffetelli, who's going to make his remarks broadly on the themes of the current challenges to the sovereign, the restructuring architecture, whether the order or sequencing of the restructuring of the various groups matters for achieving a quick resolution, and maybe potentially also give us his thoughts on the use of state contingent debt instruments. So Bruno, the floor is yours.
Thank you, Cesar. Thank you, Cesar, Manjuka, and also Professor Alfo for inviting me to this panel, and which is very interesting. Have the privilege to be sharing here the panel with people like Justice Silva and Reza. And I'm going to touch on 3 or 4 or 5 points on my presentation. The first one would be basically the type of sovereign debt restructuring. Second, I'll go to the challenges of the current wave on sovereign debt distress. And then what is the order of sequencing of an action plan of a restructuring. I'll give you a little bit of my experience in Ecuador, which was a very successful restructuring that we did it back in 2020 and 21. And finally, talk briefly about the new instruments or financial instruments that might be used for future sovereign debt restructuring. In terms of debt restructuring, I think that the first thing that we need to take into account is that countries never go into bankruptcy. So at the end, I mean, the restructuring of a sovereign is a negotiation process. It's very opposite to corporate restructuring because there is no intervention of court, there is no final ruling. So you have all these multiple stakeholders, which Reza was referring, that need to go and share the burden. And then as a consequence of that, obviously, since each one has to put a little bit on the share, the end result is far from optimal for all these stakeholders. So because everyone has to give up something. So this process is a negotiation process, it's a building consensus process, which at the end results in a successful, needs to go into successful sovereign debt restructuring. Which are the types of debt restructuring? I mean, I'm going to be brief on this. Obviously, we have preemptive debt restructuring, and those are the ones that sometimes not all the countries have the fortune to go into a preemptive one. It depends so much on the circumstances. I mean, the preemptive one is the one that you can do with avoiding default. Or even if you go into default, you go into default in an orderly fashion. I mean, you go into default after an DSA has been negotiated with the IMF. And so examples of that, probably the recent case of Ghana, where we just announced a moratorium after DSA was approved by the staff level of the IMF. On a more successful one, obviously the Ecuadorian one back in 2020, where we navigated through the restructuring without going into a payment default or even an event of default during the entire process. Disruptive, or basically disruptive restructurings, are the ones that follow disorderly default. Argentina, it's probably an example of the one that has done that in the past. The most recent one, probably Sri Lanka, that was a disorderly one. And those ones probably tend to be more complicated. And then challenges on this new wave, I see that obviously I see that there's going to be a long, fragile situation for low-income countries. And the reason is, and even for emerging countries, the reason is because today, I mean, low-income countries, they do not affect global markets. So a low-income country can be a long time in default, and that doesn't affect really the global markets. And that's a problem. And that's a problem because that's basically what we are facing in situations where countries like Zambia or Ethiopia that try to follow the common framework, and they have been there for months and now even close to years without resolving the situation. And that's a big problem. Another challenge that we see these days is basically the role of China. But not only China. I mean, we have other important official creditors like India and even the Kingdom of Saudi Arabia that want to play important role now. I mean, they want to be also big boys into the table, and they deserve to be big boys into the table because now they are basically the largest official creditors, mainly China. So, and this brings this contention between Paris Club and non-Paris Club, and that's also some of the challenges that we are facing these days. The other one is that bondholders are basically the most important private creditors, no longer the commercial banks, because bondholders have even become important private creditors in low-income countries. As the low-income countries were able to access to the markets the last, let's say, 5 or 10, 15 years, now bondholders play an important role as well. Reza referred to the equal treatment concept, and he made an excellent explanation that equal treatment is more a debt sharing issue and a burden sharing issue than really treatment, because treatment, what is treatment is about it. But anyway, he made a great presentation on the subject. I think another one important challenge is that we understand the importance of the IMF and the multilaterals because they are the lenders of the last resource, but they already have a large piece in the pie. So basically, I mean, I'm putting more money, and they're the ones who have to come and put more money, and they're going to be untouched. They're going to be always outside of the perimeter. But but the fact that they're going to come and put more money into increases basically the challenges to reestablish market access, because obviously they will continue to be lenders of credit, in certain ways secure lenders without any haircuts, so they need to be repaid without any specific sacrifice in terms of cut. But that establishes a problem on market access. And obviously, probably the last challenge that I face, that we see probably these days, is financial assurances. I mean, obviously the IMF wants to make sure that financial assurances for other official creditors are given at the right time, because they don't want to be the only ones really coming. So they want to make sure that once they come, also the flow of money from official creditors is reestablished. DSA is, I think that DSA is an important piece on today. I mean, it has always been, but these days is probably more important because it's set up basically the scenario for the upcoming debt restructuring. But DSA has issues. I mean, DSA is based on assumptions. It's based on targets. And as Reza was referring before, I mean, obviously, those assumptions can go wrong. And they may be wrong, not necessarily because the calculation were probably made wrongly, but because probably there is a deficiency or disappointments in the policies to be adopted or due to be adopted by the country. And there are many examples of disappointments. I mean, obviously, Argentina probably is the champion of that. I mean, they've been the disappointer of the policy executions. The challenge then is also on the creditors coordination. And as I said before, as Reza also mentioned it, this situation between the official and private. On the private creditor side, I mean, we have been able to develop some techniques which are pretty useful. They have proved to be very useful, like the collective action clauses. But we don't have such a techniques in the official side. So in the official side, I mean, basically everything has to build up by consensus. So, and that delays things. And that perimeter, and as I said before, I think the fact that the multilaterals are already have already a large piece of the pie complicate things a little bit, but at the end, they are the lenders of last resource and they need to be out of the perimeter. And that has been basically the history. They are always out of the perimeter. China now is pressing. I mean, that's one of the points of China is making into the tables, why they have to take haircuts if the multilaterals do not take haircuts. And that's an interesting discussion. I don't think that the situation will change. I think that the multilaterals, especially the IMF, will always be outside the perimeter. But again, China is putting this into the discussion. Okay? And on another topic, another challenge that we are seeing these days is the problem of the local domestic debt. The local domestic debt, it's becoming an important part of the unsustainable position of the countries. It wasn't the case in the past, in the 80s or the 90s, in the other waves of sovereign debt restructuring. But today we are seeing that that there is a big component of the unsustainability path, which is basically tied to the internal debt. And touching and restructuring internal debt obviously has consequences on the financial system of the country and the banks, insurance companies, but also has a social component. I mean, that's as the holders of this debt are pensioners or retirees, then you'll be touching a socially important social issue. You're gonna apply haircuts to those instruments. And that's a major challenge that we will be seeing in this new way. As for the action plan, and Manjuka told me to talk a little bit about what is the action plan and the sequencing in a sovereign debt restructuring. There is no single rule. I think it all depends on the perimeter. It depends if it's a preemptive or a disorderly process. It depends if we have a standstill in place or if we are straight a moratorium position. And then it depends also what is the role of the official and the private. So I think that there is not a particular, rule or plan or sequencing. But I think that at the end, and in all sovereign debt restructuring, what you need is basically a multi-front and simultaneous plan. So you need to work in different aspects at the same time. And I think one of the aspects, the key aspect, is to keep dialogue open with all the creditors. So you need to go into this consensual building process. So you need to keep the dialogue open all the time. And then so you need to decide if you're going to go with a standstill or not. I mean, so you're going to request a standstill for a breathing space or not, or just go straight into the moratorium. But that depends also so much. I mean, what is your position? What are your maturities coming? I mean, if you have some leeway in the maturities that are coming in the next months or years. And the IMF, obviously engaging the IMF is key. I mean, the DSA is obviously the most important thing, and it's required for the bondholders' consent. It's required for agreement with the board of the IMF for a policy program. It's required for the engagement with the bilaterals, and then is required also for eventually if you're gonna need and if you have an urgent need, like establishing a liquidity fund for the local financial system. So obviously the other multilaterals like the World Bank or others, or the of the regional multilateral entities, that will require a DSA, appropriate DSA. And then you need to look at what is going to be your strategy on tax, on collective action clauses. So you need to look at what are your available cases. You have CACs, or the same CACs in all the series, or you may have a series that was left behind without CACs. So you need to then plan how you're going to do, and then the CACs application. And obviously an analysis on the local debt is important these days, as you need to look what are your tools on the local legislation to deal with the local debt, if the local debt is going to be part of the restructuring, and assuming that there are local debt, most likely there will be no CACs. And so you need to look exactly what can be your tools on their local legislation. And then, so I think that I want to just touch briefly on what was our experience in Ecuador. If I have 3 or 4 minutes, Manjuka, and Ecuador,
Please do.
and then leave for the last speaker. In Ecuador, basically what we did is we basically, Ecuador was a country that was hit by the pandemic. Probably its debt became unsustainable as of March of 2020, and because obviously all the economy was impacted by the no revenues from tourism or oil. So the government immediately said, and they looked at that and said, I mean, we need to come with a plan, a long-term solution, especially for the bond situation. And so what we said is a plan on two phases. So the first phase was to try to negotiate a breathing space with mainly with the bondholders. And so we went through the bondholders and we went through a consent solicitation process for to get basically this breathing space period where we will basically negotiate with the IMF, the DSA, the program, and then implement also the solutions with the debt perimeter that we would have established. So we work on the debt perimeter, and Ecuador was a quite unique situation, and we included in the perimeter obviously the bonds, the private creditors, and we did not include all the officials. But we included China was by far the largest official creditor of Ecuador, so China was included in the perimeter. The repos of the central bank were quite a problem for Ecuador at that time, so they were included also into the perimeter, and we went to find a solution to all these three fronts during the breathing space. And so what we did then basically work with the IMF for the DSA, and once we had that, we engaged with the bondholders committee. And when we had an agreement with the bondholder committee, we basically we implemented the CACs, and we had that 96% participation in the consent solicitation, the second consent solicitation, which was for the exchange. And then what was important is that all the channels of communications were open. I mean, even with commercial banks, because even if we wanted to avoid, we got the breathing space to avoid a payment default. We wanted to make sure that we were not in non-payments defaults. So we went to the commercial banks and also to the Chinese creditors to get the proper waivers to go into the restructuring process. And then so that, because usually, I mean, the commercial loan and documentations have these restrictions that you cannot enter into restructuring discussions without triggering a default. So we got the proper waivers to manage that situation. And all the time, we had the right discussions with the right people at the IMF. And then we, as I said before, rapid engagement with the creditors committee of the bondholders was crucial, and getting their support. I mean, they publicly supported the deal. And once we had a deal with them, and that was also crucial to generate momentum for the voting into the CAC system. And finally, we also were very rapidly, successfully, we defeated an attempt to disrupt the process in a New York court by a few holders that tried to get an injunction to stop the entire process based on the fact that the collective action clauses were not valid under New York law. And we basically intervened into that process in record time and defeated the petition of the injunction in New York court. So at the end result in Ecuador was got 6.5 million extended funds facility from the IMF. We restructured the $18 billion in international bonds, getting an NPV haircut close to 40%, and then 6% haircut on principal, 2 years of grace period and payments of principals and interest, and extension of maturity from 6 years to 12.5 years. On the China front, basically the China situation was dealt in two stages. The first stage was to get a first grace period for 18 months, for a year and a half, on no payment of principal and interest, which we got it back in, at the end of 2020. And then once, I mean, that first initial grace period ended, which was at the middle of 22, then Ecuador engaged again with China and got a longer restructuring in China terms, which basically was extension of the maturities. For the case of CDB, the maturities were extended from 2027 throughout, from 2024 through 2027, and China Exim were extended throughout to 2031. And with China Exim, they got also a reduction in interest rate and an additional 6 months of grace period. So I think that I just want to stop there. I had a few comments on new instruments, but I think that I extended my time, Manjuka, but I'll be happy to talk about the new instruments in the Q&A and also address other questions.
Perfect. Thanks for those remarks, and surely you'll get questions in the Q&A about your experience in Ecuador and other stuff. So we'll be getting back to that, Bruno. Thanks. Now let me introduce our last panelist, Patrick Curran. And so Manjuka and I asked Patrick to maybe speak on the following. So we sort of prompted him with this sort of sequence of thoughts. We're thinking bondholder negotiations tend to focus much more on value recovery and exit yields rather than on the economic fundamentals of the debtor country. And so our question to Patrick to sort of jumpstart his comments is: will the bondholders benefit more in engaging with this with the debtor country to develop a macroeconomic framework that delivers more sustainable economic recovery? So that's sort of one starting point. And a related thing is that there seems to be a strong focus on nominal or say book value haircuts, and less so on changes in the market value of the debt. So shouldn't the focus be from the bondholders' perspective be on a treatment in order to eliminate the effects of debt overhang on economic growth and therefore help the country grow faster, which will eventually increase the market value of their holdings? Wouldn't something like that be a more ideal approach or solution? So Patrick, we are happy to take your thoughts on this.
Great, thank you, Cesar and Manjuka, for moderating this excellent webinar. Thanks to the other panelists for 3 great presentations. I think they've covered a lot of ground here. So I'll try to be complimentary and keep my remarks as brief as possible to leave some time for the Q&A. On your question, Cesar, I think bondholders do care about economic fundamentals like other creditors, which ultimately determine the long-term success of the restructuring, and can and do play a central role in shaping policy discussions on the macro recovery if they're allowed to. Often, though, to the contrary, bondholders are kept out of negotiations until these factors have already been effectively fleshed out by the government and their official sector creditors. I think it would be better, to your point, and bondholders themselves would prefer to be brought in at a much earlier stage so they can contribute to the policy discussions. I think, in fact, bondholders often try to engage with countries before default even occurs to proactively manage their liabilities and prevent a crisis from happening where possible. This is what happened in Zambia, for example, where the need for restructuring was apparent to many years before the government acknowledged that reality, which only made the crisis worse and made it that much more difficult to solve when default did occur. Once default does occur, bondholders are only brought into the process after the IMF program has been negotiated and designed by the government and its official creditors. And the DSA has been finalized and approved by the IMF Executive Board. And importantly, once official financing assurances have been received. This means that they're effectively presented with a fully baked restructuring and asked to provide comparable relief, which Reza already discussed in great detail, to the terms already agreed between the government and official creditors. If they disagree with the assumptions of the program or DSA, either because they think they're too conservative, not conservative enough, or maybe the debt reduction targets are more aggressive than what's needed in their opinion, then this can cause disagreements. This is exactly what we've seen in Zambia, which has been one source of delay in the restructuring process. Happy to discuss the specifics of the Zambia case more in the Q&A, but I think I'll leave it at that for now. I think engagement earlier in the process before the IMF program and DSA are finalized would have saved valuable time by allowing them to air those concerns earlier in the process. On your second point, which is the focus on nominal haircuts over market value factors, I'd say ultimately bondholders, like all creditors, are aiming to strike the right balance between minimizing the amount of relief they have to provide upfront while maximizing the chances that the restructuring restores debt sustainability and promotes sustainable growth and development over the long run. More limited relief might look good on paper off the bat, but in practice will lead to higher exit yields, either immediately due to doubts over the success of the program, or over time as yields increase in the secondary market and debt vulnerabilities build back up. So, while it may be tempting to negotiate a relatively light restructuring, and I think this speaks to the point you were trying to make, ultimately this only for long-term investors comes back to bite them in the long run. So it's really about striking that appropriate balance between making sure it's sufficient, but not overly punitive for the creditors. And I think one example of this is investors want to avoid what happened in Argentina in 2020. For example, when a relatively light restructuring was effectively pushed through by a small subset of creditors without an IMF program in place, which really is the norm when restructurings occur, because the IMF, as a sort of neutral third-party arbiter, serves as a backstop and guarantor that the government will commit to reforms. Recovery value was initially quite high in the 50 to 55 cent on the dollar range in Argentina. Exit yields were in the high single digits, so quite low when the restructurings closed. But prices immediately plummeted in the secondary market as the credibility of the restructuring program was questioned. And at the height of last year's sell-offs, bonds fell below 20 cents on the dollar and are now trading in the low 30s. So this is a good example of what happens when a light and insufficient restructuring without the necessary reform commitment, which again Reza described earlier in the panel, is pushed through. There can be short-term gains for creditors that are able to sell out in the secondary market before that collapse happens, but ultimately for longer-term buy and hold investors, the results are not positive. On the question of nominal haircuts versus other types of relief, I think ultimately investors are more concerned about the NPV of relief than they are nominal haircuts per se, which are just one component of this. In practice, there's a menu of different ways to deliver debt relief, and I'd segment them kind of broadly into nominal haircuts and cash flow relief. The latter would include things like coupon cuts, grace periods, maturity extensions. And on top of this, there's sort of a third moving part here where the government may have the option to throw in sweeteners like value recovery instruments, GDP warrants, which I think Bruno had mentioned he might be able to make some remarks on in the Q&A section, and I'd be very interested to hear his thoughts on where the architecture is headed in that space. In practice, different creditors will have different preferences as to how relief is delivered. Some, like China, prefer not to take any upfront nominal haircuts to the principal value or face value of their instruments, and instead offer cash flow relief, like maturity extensions, for example. Other creditors may be more willing to provide nominal haircuts in exchange for what they might view as a more normal coupon structure. All else equal, higher discount rates should skew the preferences more towards nominal haircuts and away from coupon cuts, as principal payments occur further in the future and will be more heavily discounted than coupons. So in today's relatively high rate environment, maybe that makes nominal haircuts a more attractive route than cash flow relief. But again, all else equal, there's a lot of other moving parts there. Ultimately, the key point is that relief needs to be equal across creditors in NPV terms and aligned with the IMF's macro targets and DSA. Aside from the terms of the debt relief, bondholders will be keenly interested in the perimeter or envelope of the restructuring. As multilateral institutions like the IMF and World Bank are super senior creditors, like Bruno described, borrowers with a large proportion of their debt stock as in multilateral loans will effectively have a lower restructurable debt pool, which leaves more relief to be provided by the remaining creditors. However, the super seniority of multilateral institutions is currently being challenged by China, which in the case of both Zambia and Sri Lanka has asked multilateral institutions to participate in the restructurings and take haircuts. This challenge is a key pillar of the sovereign restructuring architecture, where MLIs are accepted as being super senior due to their role as a lender of last resort and highly concessional financing terms. And I think China's insistence on their inclusion really threatens to delay or even derail the ongoing restructurings. This discussion is very timely. The G7, IMF, World Bank, private creditors are currently holding virtual discussions today on resolving some of these restructuring impasses, and we'll be meeting in India next week to discuss it in person in greater detail. So I think we'll all be keenly watching what comes out of those meetings and if they're able to come to some sort of understanding on that front. Beyond the question of multilaterals, bondholders will in general want the perimeter of the restructuring to be as wide as possible. In the Sri Lanka case, for example, early on, the government said that they would exclude Sri Lanka development bonds from the restructuring, which for context are dollar-denominated bonds issued under domestic law and held largely by domestic creditors. This wasn't well received by bondholders, and the reason is that the less debt that's included in the restructuring, the more the creditors that are participating will have to contribute in terms of debt relief. That's also why, in general, bondholders would prefer that domestic debt is also included. This is another important part of the conversation in the Sri Lanka context, and is also relevant in Zambia, where China is asking for domestic debt held by non-residents to be restructured. Again, this is a really delicate and complex issue. I think rather than dwelling on it, maybe I'll leave it for the Q&A if there's anyone who's specifically interested in it. And then lastly, I'll touch on discount rate, which Reza already discussed a little bit, but in general, equal treatment as a principle is a pretty vague and ambiguous idea, right? And one reason is that different creditors in practice have different discount rates that they value their debt. Multilateral creditors and bilateral creditors generally use 5% as their discount rate when they're calculating NPV relief. But from the private creditor perspective, this is well below the relevant market rate for bondholders. And this is especially the case after the sharp rise in yields over the past year. So the average yield for the emerging market high yield sovereign index has risen from about 7.5% in the decade before the pandemic to 11% today. And it reached as high as 13% at the height of the sell-off last fall. So while private creditors would typically use an 8 to 12% exit yield range historically in restructurings, I think a higher range is probably now appropriate given how high performing debt yields are at the moment. Zambia, again, is a good example of the implications of this for private creditors. The government has requested NPV relief equating to 49% across all its creditors. At a 5% discount rate. If you value this same relief at a 12% exit yield, the NPV value would actually be 69%. So it would add 20 percentage points to the relief being offered by private creditors. Conversely, using different discount rates to calculate NPV would result oftentimes in private creditors providing less relief. And one study by the IMF, I think back in 2015 or 16, showed an average difference of over 20 percentage points in the NPV reduction between official and private sector creditors. So this, again, is a really difficult issue to balance. I think moving forward, there needs to be broader agreement about how NPV relief is calculated. So there's not such a difficult conversation that has to be rehashed anew every time this comes up. In general, I mean, I'll conclude by saying recent restructuring seem to be moving much more slowly than the 1 to 1.5 year average we've seen in recent decades. And this is especially the case for countries where China is a major creditor. For example, again, in Zambia, which is a good example, it took just over a year after Zambia first defaulted to receive its IMF staff level agreement for a program, plus another 6 months after that for the official sector creditor committee to be formed, and another 3 months further before financing assurances were provided by official creditors, and board approval was secured from the IMF. And here we are now 27 months down the line, and its restructuring is still very much stuck in the mud. Again, largely driven by disagreements with private bondholders and with China about the role of multilateral creditors in domestic debt. Sri Lanka, things seem to be moving more quickly there. It's received financing assurances from, it seems, most, if not all, of its official sector creditors, excluding China, which again is facing the same issues and disagreements that it is in Zambia. So I think now there's increasingly a conversation about how we can sort of unstick this restructuring framework. I think there was a lot of criticism early on that problems were derived from the common framework for debt restructuring. I don't think the common framework has made things better necessarily, but I don't think it's made them worse either. You're seeing the same problems, whether restructurings are taking place within or outside the common framework. I think it speaks more broadly to the increasingly diverse group of creditors, right? So these disagreements, the last time there was a major round of sovereign restructurings in the 90s, weren't so severe because the Paris Club held most of the outstanding emerging market sovereign debt. However, with the rise of commercial creditors and non-traditional, non-Paris Club bilaterals like China, India, and others in the GCC, there's now a much more diverse and complex mix of creditors that need to come to the table and reach an agreement, any of which can hold the process hostage effectively by refusing to participate. More recently, the IMF has utilized its lending into arrears policies to adopt a more flexible definition of financing assurances and try to move the process along where agreements might be hard to reach. But equally, this process can backfire, as it has in Zambia and Suriname, for example, where financing assurances provided by China and other creditors were relatively vague and have failed to crystallize into actual debt relief. Other approaches that have been discussed in the Sri Lanka context include using a most favored creditor clause to push the restructuring forward without needing financing assurances from all creditors. But this is still a relatively new and untested approach. It's not completely without precedent. And I'm sure the people with a law background in this room are much more well qualified to talk about the potential pros and cons of this approach. But I think it maybe will be an interesting direction for the restructuring architecture in the future. Overall, I think there's a clear need for reforms to streamline the debt restructuring process. And again, there's meetings happening today and next week to that end at very high levels. But best practices take time to develop and refine. And I think philosophical differences between the Paris Club and new creditors like China will be pretty difficult to bridge. Sri Lanka, as well as Zambia, I think will be two important test cases and will set major precedents for future restructurings. So far, there's been a lot of difficulties, but I think everyone in this room hopefully is hopeful that those differences can be resolved and that future restructurings won't take quite as long as they've been taking in the post-pandemic era. So I'll leave it at that. Happy to address any of these topics in more detail in the Q&A section.
Thanks, Cesar. Thanks, Patrick. I'll just take a few questions. We're running a bit of over time. I just benefit that a lot of Sri Lankan audience in this case. So Bruno, if you don't mind, I'll take with your permission. I'd like to put you on. Bruno? Hello?
Yes, I'm here. Yeah.
Just put you on liquid or spot. I mean, they'll be keen on listening to you a little bit what's happening in Ghana. Just that with the few questions that were the decision to start the domestic debt restructuring, was that deliberate? And can you tell something about that, since the domestic restructure is almost over? Can you tell about the uptake and thirdly, the mechanisms in place to ensure recapitalization of banks? And thought, if you can share, if it's possible to share some thoughts for Sri Lankan audience, particularly.
Well, this is quite new. I mean, as you know, the Ghana just announced a couple of days ago the results of the local debt restructuring, which was a process that we started back, I think, 2 months ago, and the results that were announced were very good. I mean, we got probably around almost 90% participation of the holders that we wanted to participate at this stage, which are basically, we tried to go with all of them, but then over as things move along, we excluded the pension funds and leave them for a second round. But except for that we needed to exclude them, we had almost 90% participation of the rest, which are basically primarily banks, local banks, and insurance companies. And so it's a problem why we decided to go with them first. I think it's part of this plan, and as I said before, there is any country is different. I think that Ghana had the opportunity at this time to do something in the local debt, so we decided let's go for it now, and before moving with the foreign one. And I think it was just, I mean, as I said before, there is no particular recipe so each country is different. And so we completed an important part of the domestic one. As I said, that the pension funds are still there. I think that's we are going to try to complete them in the next 2 or 3 months. Let's see what happens. And then while at the same time we initiate the foreign restructuring. So I think this is all I have to say. It's a difficult process. It's not an easy process. We have to change the conditions 2 or 3 times, and obviously understanding and the discussions with the banks, the insurance companies were not easy. I mean, but we had, genuine discussions with them, and we made some amendments to the initial terms. I'll reach out to a good deal for them, a good deal for the country, and I will see. So I'll say that we are probably halfway, probably more than halfway, for 60-70% on the local debt. Let's see if we can complete the rest in the next 2 or 3 months and keep going.
Thank you. Just another question, guys. If you taking on the current defaults, I mean, Reza, Bruno and Reza have been around for some time. Do you think that if you were to, do you think that it's there is a danger of systemic risk because the current defaults, or do you think it's one-off? And if you look at the defaults in the past, would you put it like, this analogy can be drawn between the Latin American defaults or the Eurozone, or do you look at, or it's the post-Brady plan defaults? And just another question that arises from that is, do you think there is a room for a Brady plan or a use of unused SDR to be used as to resolve the crisis in a more organized manner?
Happy to share some thoughts first, Manjuka, and then also to learn from the perspectives of others. I think if I may address the question you posed about whether there are going to be systematic defaults. And I would like to answer by saying that I think it would be good to focus on a more important, related, but more important question. The cost of the sovereign debt problems, of course, manifests itself in a default that may occur and the period that a country is excluded from normal financing. But when we just limit ourselves to that discussion, we actually miss out on the cost of debt overhang. And to me, the right question is there going to be a lot of loss of economic welfare increase in poverty below optimum growth rates because of the debt overhang that a number of countries are experiencing. And there, I think there are significant concerns, because if you look at the IMF projections, for instance, in their baseline scenario for emerging markets as a asset class, in their projections from the World Economic Outlook and the Fiscal Monitor, they are projecting debt over GDP to grow by 15% of GDP over the next 5 years. And this comes on a 15% of GDP increase over the previous 5 years. And this is the average figure. So if it's the average figure, that means that there are many countries which are well above that average. And debt levels of 60, 70, 80, 90% of GDP for many emerging markets that are not hard currency issuers means that investors in these countries are not going to be taking a long-term horizon to invest and raise growth. And that, to me, the issue of living below what one can achieve is, to me, the real question that we need to focus on. The debt default that may occur is the most extreme, reflection of it. Think of it as, people or patients who are getting, weak and weak, are being stunted, or are getting, somewhat sick. Debt restructuring is just the final part when somebody ends up in the ER. But if we just focus on the set of patients that end up in the ER, we do not talk about everybody else whose growth has been stunted. And that, to me, is the question I think we should focus on. Debt levels are high. They're much higher than they have ever been. Costs of financing are much high in dollar terms. And I'm not the expert on US interest rates, but conventional wisdom is that they're going to remain higher for longer. And then on top of that, if you add all the other geopolitical type issues, then the outlook for reducing debt levels is challenging right now.
Bruno, any idea, any thoughts?
No, I will just say, I'm not optimistic. I think that the crisis is going to increase, and solution. And as I said, the problem is that low-income countries and even emerging markets now do not affect global markets. So there is, I don't think that there is the interest to come and solve the problem. Like, you said, if there is going to be a Brady plan, actually, I think it's going to be more difficult this time. China, bringing China into the discussion. China is the largest official creditor of most of these countries. And again, it becomes geopolitical at the end. It's a geopolitical game that probably will delay the long-term solution.
Okay, thank you. I think we've run out of time. I'd like to thank Notre Dame Law School for hosting this and the very insightful conversations that we had. And I think there's a lot of take home from it. I would thank Professor Alfred for putting this together and helping me. And I thank all of you. We have some very distinguished audience with us, spending our time in the evening on a Friday evening, listening to this. And I think we have enriched our knowledge because of this. Thank you, Reza. Thank you, Bruno, Patrick, and thank you.
Thank you. Yeah, thank you, everyone. That was wonderful. Thank you so much, Manjuka, for organizing.
Thank you. Bye-bye.
Thank you.
Thank you, everyone.
Thank you. Bye-bye.